Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss a judgment delivered by the Honorable Supreme Court of India in a case of 307 Indian Penal Code. Friends, you all know Section 307 relates to attempt to commit murder. Normally, in so many precedents, previously decided decisions, we have been saying that to add or to give conviction in a case of 307, the injuries should be on the vital part, injuries should be fatal, so that they may be able to cause death of a person for sure. All these things we have discussed previously. But Honorable Supreme Court of India said conviction can be given even though the injuries are simple in nature, basing on the facts of the case. This is what is stated by none less than the Honorable Supreme Court of India in Criminal Appeal number 1183 by 2011, decided on 23rd August 2023. This you can read the case as Sec.307 versus State of Maharashtra 2023. Of course, the incident took place in the year 1995, and that too against a police officer, head constable. So, without bothering much, let us go into the factual matrix. What happened? Right. In this case, on 10/3/1995, the Nanded police, actually Nanded district, Itwara PS, they have received complaints against ask.KHAJA, who is allegedly a local rowdy and collecting ransom from the local sundry people, sundry sellers. He is collecting money from them. You might have seen in the old films, the rowdies come there, they will collect mamuls from the petty sellers. Sundry sellers means people who are hawkers, who sell articles by keeping them on rickshaws and things like that. Basing on the complaint, the SHO or officer in charge of the police station directed ask.KHAJA, he is Muhammad Khan Pathan, head constable, to inquire into the matter, to get him to the police station, if necessary, reach the case. Basing on the orders of the SHO, head constable, that is Muhammad Khan Pathan, and his staff, went to Etwar on the next day, that is on 11/3/1995, having come to know that that man was present. They went to the place, literally in police language we can call they raided the place, but on seeing them, the appellant, that is ask.KHAJA, he started running away. He took to his heels, because normally nobody wishes to be caught by police. He was running away. The police followed them, and near a masjid they caught him. At the time, in order to rescue himself from the police, that is his version, he tried to, actually he attacked the head constable with a Gupti, Gupti, in Hindi, in Marathi language, I don't know what does it mean, maybe a knife or something. He attempted to hit him, he actually hit him with the Gupti on his head, but see who is on the other side. He is a policeman. He knows how to defend himself. So immediately he has drawn back, but the Gupti caused injury to his right shoulder. The matter was reported in the police station. A case of 307 IPC was registered against him. He was arrested, sent for remand, and of course the lower court gave him conviction of 5 years under Section 307 of the IPC. Of course, Honorable State of, that is High Court of Maharashtra also confirmed the same. So ultimately, as a last resort, this man, ask.KHAJA, filed an SLP before the Honorable Supreme Court of India and the matter came before the court. Now the very important point the defense raised is that your millards, the injuries are only right shoulder. The injuries are very simple in nature. Then how can it be 307? At the most, it can be 324. That's all. No serious injury. Then, for nothing, our people, our man, that Khaja has been convicted for 5 years. So, he has shown so many precedents. The advocate on behalf of the appellate also stating that for giving conviction in a case of 307, the injuries should be on the vital part. But Supreme Court did not agree. They said injuries need not be on the vital part. You have to go into the facts and circumstances of the case. He is a head constable. When the person actually tried to hit him, he is definitely will have knowledge as to how to escape from his clutches. Or in other words, how to defend himself. In this process, when the so-called appellant Khaja assaulted him with a Gupti, he tried to avoid the blow. Incidentally, he received injury to his right shoulder. So definitely, it is an attempt on the life of the head constable. There is no other go. So the conviction is upheld. That means the appeal, Supreme Court, appeal to Supreme Court is dismissed and the sentence is confirmed. Incidentally, this man was on bail. Now he is asked to surrender to the court and suffer the punishment for the rest of the period he has already undergone. Very good judgment. So what I mean to say is sometimes the judgments will come. Normally you will be under the impression that to prove the 307 the injury should be on the vital part. By this case you might have understood that not necessary. Okay, so please read the judgment and enrich your legal knowledge. Thank you.